Okay, so good morning, everybody. We're up to well over 100 people, and it's good to have so many people join our first webinar of 2022. Apologies, been a few minutes late. Will's got a slight issue with the stability of his connection, so I'm just going to check with Will to see how it is right now. Will?
Hopefully you can hear me, Greg.
Yeah, that's clear. Thank you. And what we'll do, Will, is if you have problems, we'll jump onto my section whilst you rejoin. Okay.
Thank you.
Okay. All right. So welcome. This is our sort of annual look back and look forward. And what we've got for you today is a look back of last year in terms of cases and key pieces of legislation, and Will's going to take you through that. I've then picked out a number of cases which have started coming through the tribunals in relation to COVID to try and give you some sense for what approach the tribunals are taking to what's new stuff for them as well. And then we've got Will looking forward to what's to come in 2022. Now, many of you will have previously joined our webinars, some of you will not. The way we like to run them is that we will aim to finish within an hour. Will and I will be talking for probably 50 minutes, maybe just under, maybe just over. We try and leave time for questions and answers at the end. Now, if you have a question, if you can put it in the Q&A function on the webinar. If you have problems with your technical issues, if you put it in the chat function, then our BD team, who's online as well, they will try and respond and try and help you where they can. So questions for me and Will, do put in the Q&A function, but bear in mind that we're up against time slightly. We will do our best to get to your questions, and if we can't, as we've done before, we will circulate a Q&A document where we will answer those questions that are raised. Okay, and if you have questions that crop up afterwards, please contact Will, myself, or any member of the team. Our details are at the end of the presentation. Okay, so I'm going to pass over to Will, and we're going to all have our fingers crossed that Will's internet is stable enough. And if it's not, you'll be suddenly hearing about the COVID cases from me. But Will, over to you.
Thank you very much, Greg. And yeah, fingers crossed. Yeah, it's a typical problem of the year and working remotely. I'm sure you've all had the same issue with technical issues cropping up. But fingers crossed, we'll be fine. So as Greg says, so in this first section, I'm going to be looking back at 2021. First of all, looking at some key changes to the actual law itself, the legislation changes, and then I'll pick up on a few cases of note that have cropped up over the course of the last year as well. So starting off with the law changes, probably the biggest change, just to flag again, it seems like an absolute age since we first looked at this. I remember talking about running seminars in person with Greg on IR35 2 years ago, before we'd even heard of coronavirus. That's kind of how long ago it was. That all got postponed and then finally came into force on the 6th of April 2021. So this was IR35 in the context of the private sector. It'd been there in the public sector before, but it was introduced in the private sector in April last year. And just as a reminder of what this was, is it was looking at the issue of employment status from a tax perspective. So not from an employment law perspective, but from for the tax reasons, whether someone was genuinely self-employed or whether someone should be treated as an employee. And it only applies, that rather the law change only applies in the scenario where you have an individual worker and they're providing services to you as a business through what we call a personal service company. So in other words, the individual sets up their own limited company and they provide you their services via that company, rather than you just contracting with them direct as an individual. So it applies to that particular scenario, which in the past has been a way for people to provide their services more tax efficiently, or not tax evasion, but more tax efficiently. And HMRC have been trying to close that particular loophole. So it applies to that scenario. And how it affects you is that unless your business is classified as small, and I'll come on to what that means in just a moment, it's up to you now as a business to determine whether that individual, for tax reasons, is providing services as an employee or whether they're self-employed. In the past, it was up to the individual. and their personal service company, they had to take care of their own tax affairs. Now the responsibility shifts to you as the end user to carry out that determination. And if the impact of that determination is, if once you've gone through the bits and pieces and worked out that they are working as an employee, then it means that you have to pay them subject to PAYE, and you also have to pay employers' national insurance of 13.8%, together with the apprenticeship levy of 0.5%. So basically it becomes 14.3% more expensive to use someone's services if you determine they're an employee. And it's then a question of you sorting out with them whether you simply have to pay the extra 14.3% yourself, or indeed whether you have to renegotiate their charges so they take a hit, or indeed it's split in the middle. So that's roughly what IR35 was. In terms of the small company exemption, just a reminder of that, is that to be a small company, you have to meet at least 2 of the following 3 conditions. Those conditions being, if you've got an annual turnover of not more than 10.2 million, or your balance sheet total is not more than 5.1 million, or you have not more than 50 employees. So if you meet 2 of those 3 criteria, you're a small company and you're exempt from the law changes. For everyone else, it applies, and those figures are based on your last set of accounts before year end. So which also means that any brand new company or startup will automatically be a small company until such time they filed accounts and they go over those thresholds. Also bear in mind that when you're looking at what's meant by company, if you're set up as a group structure, HMRC will look at the entire group together, just to avoid employers splitting up into divisions and separate companies just to try and get around these law changes. So the whole group gets looked at together for those purposes. So if you're in scope, if you have workers of that kind in your business and you're not a small employer, what do you need to do? Well, as I mentioned, the main change is it's up to you to determine the individual status. So that's the big shift. So that's your responsibility to work out whether you believe if they are self-employed or an employee for tax purposes. In some circumstances, there is what we call a contractual chain. So basically what I mean by that, to give an example, is it might be that you've got an individual worker, they've got their personal services company, they then are signed up with an agency, and then the agency provides the services to you as the end user. So you've got a whole chain of contracts from you all the way down to the individual employee with other organizations in the middle. If that happens, then it starts off again as you as the end user. So the person actually using the services starts off the process and you make your determination. So you work out whether you think that the person is employed or self-employed for tax reasons. Once you've done that, you then pass your findings onto the next company down the chain. So in the example I just gave, you would pass your findings on to the agency. At that point, you are absolved of your responsibilities. And it's because the person who has to pay the PAYE and the national insurance and the apprenticeship level is ultimately the organisation that pays the PSC. So in the example I just gave, the agency would ultimately pay them. So it would be the agency that has to account to HMRC for the tax. So you can say you get rid of that liability by passing it on down the contractual chain. If you don't do that, if you don't do your bit, then it stays with you. So even if there might be other companies in the middle in a chain, if you haven't done your determination and passed it down the line, you are responsible, you stay responsible, and you will have to account to HMRC for the tax. So that's important. In terms of how you go about it, well, one way is you can simply decide yourself. You can just work out, do we believe that this person is employed or self-employed, looking at normal employment law type principles, looking at whether someone's an employee or not. But actually the better way is, at least as a starting point, is to use the government's online tool that it's called the CEST tool, C-E-S-T. If you Google that, it comes up. And basically what that does is you enter in some basic information. It will ask you questions. You answer the questions honestly, and then it will give you a determination. And the good thing about doing it that way is that HMRC have said that as long as you provide honest answers when you use that tool, and it will then generate a result page, HMRC will accept that result page as definitive proof, so they won't contest it if you've done it that way. So that's always going to be the best starting point. However, in some circumstances, your final result sometimes comes back saying that the result can't be determined, so it can't work out one way or the other. Often because of the nature of the question, some of them are very linear. There's a kind of yes or no answers, where actually the real answer is yes, it's kind of that, but actually there's a bit of an explanation behind it. So, for example, I've had clients before that have used the tool, and there's been a question that comes up that says, has this contractor provided services to other clients within the last 12 months? The reality is that the worker has set up the personal service company brand new, and this is their very first project. So of course, the answer is no, they haven't provided services to other clients in the last 12 months. Well, actually going forward, you know full well they will be able to. And flexibility to work with different people is a key factor in working out if someone's employed or not. So sometimes the tool doesn't give you a definitive answer, and in which case you can then, if it says that it's cannot determine, you can then work out yourself why do we think it is that it gave that result. Are there any other particular factors that lean one way or another, and make your own determination. And look, even though these laws are, say, coming up to a year old, they came in April last year, it's particularly important now because it's one of those things that a lot of organisations, for obvious reasons, had other priorities. It got put on a bit of a back burner, and even more so because HMRC originally announced that there was going to be a 12-month grace period for issuing fines. So unless any company was deliberately looking to evade tax, then they were not going to impose any fines for a 12-month period for people failing to comply or filling in the details incorrectly. That 12-month period is very nearly finished. So come April this year, grace period ends, fines will start getting issued. So if you haven't done it already, or you need to refresh, now's a very good time to do that audit and look through your workforce. Second piece of legislation I was going to mention very briefly is just a change around the law around protecting people from detriments if they've raised health and safety concerns. So we've already got an existing law that covers employees, and effectively what that says is that if an employee does certain things, and I picked out sort of the two main examples, one being if the employee doesn't attend work or proposes not to attend work because they've got a reasonable belief that their attendance will put them in serious danger for health and safety reasons, possibly particularly relevant in the last year or so, where people have been uncomfortable about attending the workplace for risk of COVID, for example. So that type of scenario, or alternatively, if the employee is looking to take or propose to take steps to protect themselves or others from harm with a reasonable belief that they're in danger. So if an employee is basically trying to look after theirs or their colleagues' health and safety at work, they are then subjected to a detriment for doing that. So it's kind of like a whistleblowing type claim. So someone tries to deal with the issue as a serious safety concern, they are then pushed out of the company or treated badly or overlooked for pay rises, whatever it might be. The employee currently has got a claim under in the Employment Rights Act. The change to the law is that that's being expanded to cover all workers. So if you've got people in your workforce that aren't employees, but they are working for you on a personal basis, so that's a broader category of consultants and so forth that are working for you as workers rather than as employees, the same protection is going to apply to them going forward as well. And that came in on 31st of May last year, and it's going to apply to any detriment. So, non-renewal of a contract or something of that kind, anything that happened on or after 31st of May last year, a worker can now bring a detriment claim if they were treated in that particular way. So that's all I was going to say in terms of highlights in terms of law changes. I'm now just going to pick up on particular cases that have hit the headlines or things that are particularly newsworthy and things you should be aware of from last year. So the first one, again, it was a big issue last year in terms of tax again and employment status. We've covered IR35 already. There were a lot of cases that went through the courts last year on gig economy cases. And the most famous one, or the most well-reported one of all that you no doubt came across or have seen, is to do with the Uber case. So Uber drivers and the issue of whether they're genuinely self-employed or whether they are indeed workers. This wasn't looking at whether they are employees. So as a quick reminder, in employment law, so for tax purposes, people either they're employed or self-employed, that's it. For employment purposes, you've got three categories. You've got employees, who have the most protection. Then you just below them, you have workers, who basically provide personal services to you. And then you have the genuinely self-employed, and there's different sets of rights that attach to each. And the Uber drivers, they weren't pushing for employment status rights. What their claims were about were things such as working time regulations, annual holiday, and national minimum wage. And those rights attached to workers. So that's what they were pushing for, recognition that they were in fact workers, providing personal service, basically. And the determination in the Supreme Court, which is the highest court in the land, was that Uber drivers are workers. So Uber had been treating them as self-employed, but they were deemed to be workers. And the crucial factor, which is going to be for those of you who do have workforces that are split between employees, workers, different sorts, and self-employed people, what was crucial here was the level of control. So basically, the findings of facts was that Uber controlled fare fees, driver's ability to accept or decline a request, how the driver delivered their services, and how communication was delivered between the drivers and the passengers. So Uber had a really close way of controlling to protect its brand, of sort of how all these different things were done. And on the basis of that, the court decided that because Uber controlled how the work was being done, the person wasn't genuinely self-employed. A self-employed person works out for themselves how they should deliver the services. Uber had control over too much stuff, and therefore they were determined to be workers. So control is really important. The other thing that's going to be really important, both for tax reasons and also for employment status, is, again, personal service and the right to substitute. So someone who is genuinely self-employed providing services, ultimately what they're doing is they are providing with their services. It doesn't really matter so much who it is that provides the services. What you're interested in is the end product, that services are actually being delivered. And in the case of Stewart Delivery, on this particular factor, the outcome was that it was determined that the couriers were workers, so not self-employed. And in this case, in their contracts, there was the right to substitute. In other words, there was something in the contract that says, if you as an individual are unable to provide the services, you may send a substitute to provide the services in your place, which again is really important to have that to make someone genuinely self-employed. And if you have contracts that kind, no doubt you have that exact type of wording in there to give yourself some protection. However, in this particular case, again, so the point to note is that just having the wording in the contract wasn't nearly enough. What they actually looked at was what happened in practice. And in this particular case, the way that their services worked, they had an app there that could mean that couriers could pass things over in theory to other people, but it was so limited, so difficult in practice that actually these individuals, their actual ability to appoint a substitute was pretty much non-existent in reality, and it never happened, and they couldn't really do it. So even though there was the clause in the contract saying in theory they could, the reality was they actually couldn't, and they had to provide the services themselves. And because it was therefore personal service rather than anything else, then they were determined to be workers. And then just one quickly that went the other way on the same point was the Deliveroo case. And this one, the outcome was that delivery riders are not workers for exactly the same reason, but in reverse, in that it was determined that they didn't have to provide services personally. In this particular way, the way that Deliveroo riders were set up is they had an unlimited right of substitution, and they did use it in practice. So therefore, they were deemed to be that they weren't workers. Then the last couple of things. First one, again, really interesting case on the issue of philosophical belief discrimination. which is important for a couple of reasons. First of all, because it's something that we don't really come across all that often in terms of philosophical belief having protection, something we possibly don't think about all that much. And secondly, it highlights a potential issue of conflicting protected characteristics. And basically what happened in this case was Mrs. Forstata provided services and it was on a contract basis. She had and expressed her personal view that a person's sex is a biological fact and basically didn't believe in issues of changing gender identity. So she recognized that someone could change their gender and they could ask people to accept that, but her belief was that even if someone did that, then it didn't actually change their gender. So someone, so basically a trans woman is not really a woman, they are still a man. That's basically the belief that she presented. That went against the organisation's own beliefs and looking to protect trans workers and employees. As a matter of general policy, they didn't renew her contract. And then the issue became, was her own belief capable of protection? Was it a philosophical belief that meant that she had protection against detriment itself? And the outcome was, yes, it did. So even though her particular views are ones that would offend a lot of people, what the courts actually said is that in order for it not to classify, basically a belief has to be akin to Nazism or encourage hate or violence and be completely unworthy of respect. And it acknowledged that it didn't, it put the bar very high in terms of that. And so therefore the determination was that even though her views were unpopular and could offend, it was still capable of being a philosophical belief. So she herself had the right not to be discriminated against. Now, of course, that presents organisations a potential problem in terms of when you've got those conflicting rights between the two. However, the court did go on to recognise that actually how she expresses her views is a completely separate matter, of course. So it doesn't give her licence to go around harassing people on basis of transgender or anything like that. Her behaviour is a completely separate issue. If she behaved in such a way that did harass other employees, of course, she could be disciplined for those things. But simply her holding the belief in itself did give her protection. So if she held the belief but didn't commit misconduct, then she should be protected. And then the final case I'm going to highlight, similar type of issue in terms of conflicting things, is the case of Bayfield, where basically what the company was looking to do here was address an issue in terms of its gender pay gap. So the employer had already stated its desire to change its reputation of being full of straight white men. So it stated that as a policy statement. It went through a redundancy exercise subsequently, and it selected 2 male employees for redundancy. And crucially in this case, there was a female employee who did the same type of job, and she was not even considered in the selection pool in the first place. So basically it was pretty obvious that what they were trying to do was address their gender pay gap issue and reduce the number of male employees in highly paid positions. However, this was found to be unfair dismissal and direct sex discrimination. So the tribunal noted that it had good intentions and it was trying to do the right thing. However, it had selected people directly because of their gender for redundancy. Therefore, it could only be direct sex discrimination for which there is no justification. So again, the point being here that it's not an easy fix. So that's all I'm going to say in terms of those. I'm just going to pass over to Greg.
And we're going to get you doing some work now because it's quiz time. So I didn't mention this at the start, but here's a surprise for you. We have 3 poll questions, and what I want you to do is to look at each, and they're multiple choice or multiple guess, depending on your view, and to work out what you think the answers are to these questions. And what they all 3 address is the tribunal system at the moment. So the first question is this. The tribunal stats were just published last month for the period from April to June of 2020, so the year before. So in that period, we then compare it against April to June 2019. And the first poll question is it in that 12-month period from 19 to 20, what's happened to both the number of claims issued and the number of claims resolved or disposed of by the tribunal. That could be by a judgment, that could be by a withdrawal, or could be by a settlement. So do you think the claims have increased in that 12-month period by 18% and disposals reduced by 21? Have they reduced by 9, disposals reduced by 4? Have claims increased by 6 and disposals reduced by 16? Or have claims remained broadly the same but disposals reduced by 15%? Have a guess. There is a right answer, and I'll tell you what it is very shortly. Okay. So the majority think that claims received have increased in that 12-month period. So 39% and 38%. That majority are right. So if you thought claims had gone down or stayed the same, that would be wrong. We have seen an uplift in claims. And the reduction in terms of disposals was the higher number as well. So the right answer was A. And that's certainly something that we've been battling with, and the system's been battling with. And I'll come on to that in the third poll question. But let's deal with the second poll question. We always get asked, what area of claims gets the highest award. So let's look at the stats that, again, have only recently actually come out, but for the 19 to 20 year. And the question is this: what type of claim in 2019 and 2020 had the highest average compensation award? So do you think it was an unfair dismissal claim? Do you think it was sex discrimination claims? Do you think it was disability, race, age, or sexual orientation? So the highest average, not the highest single claim. Vote now, and I will reveal all. Okay, so 1% think it was age. The majority, I say the majority, the highest is disability with 30% and sex discrimination with 28. I'm going to take you through the order in terms of the lowest to the highest. So the lowest average in that period in 1920 was race, with an average award of 9,800. The second highest was unfair dismissal with £10,800 average award. Then it was sex discrimination with 17,420. Then it was disability, so not what the highest number in our poll thought. Disability average was 27,000. The second was sexual orientation with an average of 27,900. And the 1% of you who said age discrimination were right, because the highest average was for age discrim, and it was 38,794. And quite interesting, because it changes from year to year. The previous year, the highest award was for unfair dismissal, which was a £947,000 award. It does change from year to year. I know in the last 12 months that there's been a case in the Croydon Tribunal where an award of £2.5 million we think has been made, interestingly by one of our former colleagues, Tony Hymes Parish was the judge in that case, and we're waiting for more details. We're waiting for that to go to appeal. But interesting how it changes from year to year. Right, let's move to the final question. Is this: so earlier this month, a written question was published in Hansard, which is the government, records all the government debates in Parliament. And the question was: the average length of time between ET1 being issued and the first hearing for a single claim. So if you've got an unfair dismissal claim, and the first hearing, by that I mean not the final hearing, could be a preliminary hearing, was how many days? So from the ET1 being issued to the employer, to the first PH, or to the final hearing, what do you think the average length of time was before that hearing took place? 112 days, 177, 228, or 335? Bear in mind, pre-COVID, there was a sort of structure and the tribunals had to get an unfair dismissal claim heard within a set time frame, which was quite short. Let's see what you guys think. So the majority, so it's over 50%, think 228. And the right answer is actually 335. So 23% of you got that one right. What we're finding in the tribunal, and it may come as no surprise to those of you who've got live tribunal cases, is the delays are just quite incredible at the moment. You know, we are getting cases, and they're worst in London and the Southeast because of the relative lack of judges, but we're getting cases listed for them. I had one in November, which was listed for the middle of 2023 for a multi-day case. So the tribunal system is really struggling. It's under a lot of pressure. The good news is that they've appointed a number of judges, and there's around 200 judges that have been appointed across England, Scotland, and Wales. So hopefully those delays will come down. But if you are dealing with a tribunal case at the moment and you're trying to work out how long it's going to take to take its course, it could be a very long time. And the challenge always then is to make sure you still got your witnesses available and you can fully prepare your case. Very difficult times for people managing tribunal claims. Okay, that's the last of the polls for now. And I'm just going to take you through some of the COVID cases that have come through the tribunal system. I'm going to whiz through them relatively quickly. If you want any more detail about any of the cases, then do get in touch with me, Will, or your contact in the team. I've cherry-picked ones which I think are of interest, picking out different topics such as masks, vaccines, refusals to attend work, etc. Let's crack on because we're up against time slightly. So let's deal with this first case, which is a case of Mr. Kubilius, who worked as a driver for Kent Foods over in Kent, and he regularly delivered to and from the sugar refinery on the Thames that was owned by Tate and Lyle. And on the 21st of May 2020, so start of the lockdown, early days, he drives up in his van to the refinery. He was issued with a face mask at the gate, and he was told by the person on the gate, and when he went through the gate, that he must wear the face mask whilst he's at the refinery. And he said, well, I'm in my vehicle, I'm not going to wear it, and it's not a legal requirement. At that stage, it still wasn't a legal requirement in May of 2020. So Tate and Lyle went back to their customer, Mr. Kubilius' employer, Kent Foods, and said, we don't want this guy back on site. And so disciplinary proceedings were started against him, which led to his summary dismissal. And the tribunal in this case said that his dismissal was fair. What we must think about always with unfair dismissal and gross misconduct cases is what we call the band of reasonable responses. Was that decision to dismiss in these circumstances one which a reasonable employer could have reached? Was it within that band? And what the tribunal said was, yes, it was potentially a harsh decision, but it was within that band, and certain factors were taken into account. The employer had a handbook which said that the staff must follow customer instructions regarding PPE. The employer was also concerned about his future conduct, as he continued to insist he had done nothing wrong. He showed no contrition, and they were concerned that if he would go up, faced with that situation again, he might act in exactly the same way. And the other problem they had was that he was mainly working delivering to and from that particular refinery. They didn't have other work or contracts they could move him on to easily. And so there was practical difficulties in the fact that he had been banned from the site, finding him another role. So potentially a harsh decision, and certainly it might have been different if, for example, he'd been a long server, if he had been quite apologetic, and if they were able to move him on to another contract quite easily. But in that case, they couldn't, and the tribunal said that his dismissal was fair. Moving on to the next case. I think we just go, yeah, thank you. This was a breach of the self-isolation rules case, and certainly something that I've had advising a client over the last, probably about 6 months ago. Mr. Lewis worked at this distillery as a forklift driver, and on 8th of February last year, his son was displaying COVID symptoms and had booked a test. But Mr. Lewis, Dad Lewis, thought his son was faking his symptoms to get off work. So he went into work despite the Scottish government guidance stating you should self-isolate if someone you live with was displaying symptoms. He felt, well, his symptoms aren't genuine, and therefore I can still go into work. Lo and behold, the test comes back positive. He's dismissed for gross misconduct for coming into work whilst his son was perhaps displaying symptoms. So the tribunal went against the employer in this case. And why did they do that? They said the dismissal was unfair. They said that if he didn't actually believe in his son's symptoms, then there was no requirement to self-isolate. He'd been there a long time, 23 years unblemished service. And he was clearly someone, Mr. Lewis, who followed the rules, as shortly before that, he had complied with the guidance and had self-isolated. There was no financial impact on him, so it wasn't that he was trying to come into work because then he could earn money, because even if he'd been isolating, he would have been paid in full by his employer. And the tribunal felt that the company hadn't tested his belief about his son's condition. So that feels quite a harsh outcome, I must admit, to me, because it all came down really to whether or not Mr. Lewis genuinely believed his son's symptoms. There was a reduction for contributory fault, so his compensation was reduced by 25%, but he was still awarded the best part of £24,000. Okay, this case came through last week, so we've added it in, and it's the first case that we've seen in relation to vaccinations. So absolutely timely, given that many employers are still battling with what approach to take for the unvaccinated. This was a care home case, and Mrs. Elect was a care home worker. And in December of 2020, they had an outbreak of COVID. They had vaccinations lined up. It was just as the vaccination came through. And as you'll probably remember, care home workers were top of the list for vaccinations. They had an outbreak of COVID in their care home. It affected 33 staff, 22 residents. And a number of the residents passed away, sadly, as a result of COVID. And what the care home said was that everyone in this care home must be vaccinated. And in the middle of January of 2021, Mrs. Elect was due to have her vaccination. The day before, she realised that she was under threat of dismissal if she didn't agree. She said, I'm not going to do it tomorrow. I'm not going to have my vaccination. And her reasons were around concerns about the safety of the vaccine, the fact that she felt it had been rushed through, and she had read stories on the internet about it being part of a government conspiracy. So the employer called her to a disciplinary hearing for failure to follow a reasonable management instruction requiring her to be vaccinated. And at the disciplinary hearing, she said, well, actually, also, I have a religious objection because I'm a Rastafarian. It was the first time that she said anything to her employer about being a practicing Rastafarian. So the disciplinary took place and she was dismissed. And if she remained unvaccinated, she could pose a real risk to the safety of the residents, the colleagues and visitors. That's what the employer was saying. They also spoke to their insurers, and the insurers were saying, well, if you've got unvaccinated staff and they pass on COVID and it causes illness or injury to, let's say, a resident of the home, then you're not going to be covered by the insurance. And so the employer said in those circumstances, we've got to dismiss her for refusing to follow a reasonable management instruction. So what did the tribunal say? They said that the dismissal was fair. They said that they accepted that her skepticism about the vaccine was genuine, but they said it was unreasonable. There was no medical authority or clinical basis for not having the vaccine at that stage. The employer had a legal and moral obligation to protect his vulnerable residents. But of course, the corollary of that is that they've got an obligation to respect their employees' wishes, I suppose you could argue. But fundamentally, the legal and moral obligation to protect the vulnerable residents was exceptionally important. Mrs. Alette raised human rights issues as well. She said it's an interference with my right to respect for my private life, which is under Article 8. But the tribunal concluded that interference with her own Article 8 right was proportionate in the circumstances. And as to the point about whether or not her dismissal was connected with her religious beliefs, the tribunal concluded that it wasn't. Her refusal wasn't connected with her Rastafarianism, because she only raised it at the very last minute. If she had raised it maybe in the middle of January meeting or even earlier before the vaccine issues arose, then it might have been different. But in that case, it wasn't connected, and the case went in favour of the employer. And I'm sure we're going to have a whole ream of cases over the coming months dealing with vaccination issues, but that's the first one we've seen. Okay, just a couple more from me before I pass back to Will. So this case of Moore and Ecoscape is one involving an individual who refused to attend work. So it's first lockdown, and the employer initially closed its site and put in place various measures to protect staff, because they needed staff to get back on site, because it was a physical working environment where they couldn't easily work from home. And Miss Moore said she didn't feel safe returning. They put in place additional measures just for her, giving her a separate office with its own facilities. And she said, no, I'm still not comfortable. I want to work from home. And they said it's just not possible, because she, in her role, needs to help with deliveries and customers. So she needs to be on site to do her role. She raised a grievance, which was rejected, and then she resigned and claimed constructive unfair dismissal and automatic unfair dismissal. Her claims were dismissed. Yes, she had genuine concerns about COVID, but her fear was a general one about not leaving home. It wasn't specifically about the fact that she felt her workplace was unsafe. The government guidance at that time was to work from home if possible, but the tribunal felt it wasn't possible in her role, because her role needed her to be on site. And the tribunal felt that the employer, Ecoscape, had taken reasonable steps to address her concerns. So in that circumstance, her claims for constructive and automatic unfair dismissal were dismissed. Okay, finally, this case I've picked out is one where we had a employee working for a community action organisation as an employment and training officer. So it's a standalone role. She was the only person in this organisation who did this role. And this role was publicly funded in part, but the funding was reducing. So just before COVID, early days of COVID, they were trying to get funding for her role, but there was just a lack of success with doing so. 17th of March 20, so just before first lockdown, she tells her employer she's pregnant. And then the lockdown announcement came through on the 23rd of March, as we all remember, and she was advised to work from home. 30th of March, so a week later, the employer holds a meeting with staff and says there may be potential redundancies. But Ms. Sane and one of her other colleagues who was shielding weren't invited to that meeting because the employer didn't want to put their health at risk. 6th of April, she was placed on furlough. And whilst on furlough in that first week, the employer started a redundancy process where they did a scoring exercise. They pulled Ms. Sane with her colleagues, and there was a matrix put together and scores were given. On the 14th of April, so just a week later, she had a consultation meeting, and she was told of the outcome of the scoring and of her potential redundancy. And she took it that she was being made redundant. She was very upset, and the meeting was brought to an end. So there was no real discussion other than her being told that a scoring process had been done and that she had been selected for redundancy. Then a week later, she was taken off furlough and she was issued with notice by her employer. And the question that arose there is, was her dismissal unfair, and was it automatically unfair because it was connected with her pregnancy? Moving to the next slide, please. So what the tribunal said was that prior to her revealing that she was pregnant, there was already funding issues for her role. And so there was no connection between her dismissal and her pregnancy, because the redundancy situation, the reduced funding for her role, had already arisen before she told them that she was pregnant. However, she was unfairly dismissed because of the scoring process that was undertaken was fundamentally flawed. Her role wasn't interchangeable with colleagues. And what most of us, I think, would probably know, and the approach we would take, is where you've got a standalone role, you don't need to pool and select them necessarily. And so the mistake the employer made here was that they put her in a pool with other people. If they just left her on her own in a standalone role and said, the funding's dropped, we need to make cutbacks, we can't support your role, they probably would have found it as a fair dismissal. There's also a lack of meaningful consultation in this case, because she was told at the meeting on the 14th of April that she was redundant, the scoring had been done, she breaks down, there was no further discussion about it, and no alternatives to redundancy were considered. So it was an unfair dismissal. And as I've said, but there was no unfavourable treatment because of her pregnancy, arising from her failure to attend the 30th of March meeting. That was the one where her and their colleague who was shielding didn't attend. It wasn't unfavourable because they were trying to protect her from being exposed to risk. So that element of her claim failed, but the unfair dismissal, the ordinary unfair dismissal, succeeded. Okay, time for me to hand back to Will. How are we doing for time? We've probably got about 15 minutes. So we'll try and do sort of 10 minutes on looking ahead, and then we'll try and pick up on some questions in the final 5 minutes.
Many thanks, Greg. So just picking up on a few highlights of things to look out for the year ahead. Again, possibly for understandable reasons, there hasn't been a huge amount of time devoted by the government to looking at new employment laws in recent times. There's not an enormous amount, but there's a few interesting things there on the radar. The first one there on the list is the introduction of a new statutory right to 1 week's unpaid carers leave. So this is something that has been approved. So it's definitely will be going ahead, which simply the one thing we haven't got at the moment is the implementation date. So we're not quite sure which date this will come in, but it will be happening at some point in 2022. And effectively what this one is it's an expansion of our current right that we have for emergency time off to care for dependents. So as you may know, at the moment, if you have an employee who has got children, parents, family who they've got caring responsibilities for, if an emergency crops up, they are allowed to take unpaid time off to deal with that emergency. Typically, it'll be a day, maybe 2 days of time off to deal with that situation. What the new law will do is cover similar sort of things. It'll be the same category of people. So someone would need to be someone in a caring responsibility for a family member or a member of their household. But the other thing is that the individual in this case is also needs to have a long-term ill health issue or impairment. And for these purposes, it will be exactly the same definition as under the Equality Act. So basically a physical or mental impairment that has or is capable of lasting for 12 months or more. So if the dependent fits into that category, then going forward, what employees will have the entitlement to do is take up to a week's unpaid leave per year to care for that or help care for that individual. And the way that will work is they can either take a full week off, or it could be split up into days or even half days, but they'll be able to take up to a week off per year to deal with that type of scenario. So as I say, that's something that will be coming in at some point during the course of the year. The remaining points are, sorry to go back one, yeah, we are simply proposals at the moment, so they're not solid law, but they are expected to develop further during the course of the year. So the first one is that they are consulting about the whole thing about flexible working, which obviously for understandable reasons is a big issue right now. So right at the beginning of the consultation, they were looking at all sorts of things, right up to, at the most extreme end, the ability for an employee to make a flexible request and the employer have to accept it come what may. So it'd be an absolute right. Thankfully, that particular proposal has been rejected as completely unworkable for employers. So the most likely changes that they're looking at right now is that at the moment, for an employee to put in a flexible working request, they have to have at least 26 weeks worth of continuous service. The most likely change is that's going to be changed to become a day one right. So someone right from their first day of employment will have the ability to put in a flexible working request. Again, as consultation sits at the moment, the employer will still have the same rights to reject a request if they have specified business reasons for doing so. So that bit we think is going to be unchanged. And the other thing they're looking at is at the moment, employees can only make one formal flexible working request per year. They're looking at changing that as well to allow employees more flexibility to make more than one request during the course of the year. So that's something to look out for, but something we expect to change or at least make decent progress during the course of this year. The next one is an extension of protection for pregnant employees in the context of redundancy. So the law, as you probably know at the moment, we've got Regulation 10 of the maternity regulations that basically says that in a redundancy situation, if there is a suitable alternative role, an employee who is absent on maternity leave must be given first choice or first preference for that suitable alternative role. So it doesn't stop you making them redundant. It just means that if there's an alternative role, they get first choice for that suitable alternative role if they're currently absent on work on maternity leave. What they're looking to do is to expand that right to basically cover the period. Instead of just maternity leave, it will start at the point that the person tells you that they're pregnant. So from the start of their pregnancy, when they tell their employer that they are pregnant, but they're still in work, so it will cover that period. It will cover the period of maternity leave, and it will also cover the period of 6 months after they've returned as well. So it's an expansion of that overall right. They're also looking at expanding it not just for pregnant employees or those on maternity leave, but also those who are absent for other family-related reasons, so for on adoption leave or on shared parental leave as well. Again, the same type of rights, expanding that Regulation 10 right to first dibs on alternative roles. There has been some talk about expanding it even further to basically prohibit someone from being made redundant at all, unless the situation is that the employee's place of work is closing down, but otherwise a complete ban on redundancy, full stop. So that's been looked at. Personal view is I suspect that will get too much resistance and it goes a little bit too far and there's too many problems associated with that. But again, one to keep a watch on in terms of how that develops during consultation and how that might pan out during the course of the year. And then the final one is the duty to protect employees from third-party sexual harassment. So at the moment, the way the law sits is that if someone outside of your business harasses one of your employees, you are not liable for that. You would only be liable for the acts of other employees or people within your organisation. So they're looking at basically putting a duty on employers, to provide reasonable protection for your staff if they're being subjected to harassment from third parties. Again, it's proposal stage at the moment, under consultation, but something to keep an eye on. And then finally, just on the next slide, just a reminder that most years in April, rates go up. So on the slide there are the details of the new minimum wage rates that will be applied from 1st of April. The other thing as well is that in April each year, normally the rates for redundancy payments, statutory redundancy payments, go up as well. The new rates for those haven't been announced yet. So we'll see what those are. But bear in mind that the closer we get to April, the more relevant they become, because the way that law works is that if an employee is made redundant before April and they are released with immediate effect, in other words, paid in lieu of notice, what you're supposed to do for redundancy calculation purposes is you assume that they have worked out at least their statutory notice, in other words, 1 week per year of service. And if that date falls on the date of when the new rates are in force, they have to be paid under the new rates, not the old ones. So the closer we get, obviously, the more relevant those particular changes will come. But as I say, the new rates haven't yet been released. Something to look out for. So just to finish up, got another quick poll for you, just in terms of looking forward, looking back. So question to you to start off with, just looking back on the last 12 months, what have been your biggest challenges in your view in the HR world? So has it been ensuring that those who have been working remotely are productive? So issues of performance for remote workers? Has it been just dealing with employment relations issues on a remote basis? Has that been your biggest challenge? Dealing with mental health, disability issues, particularly in the remote context? Maintaining staffing and improving staff engagement, or some other reason? If you've got some other reason, do feel free to pop something in the Q&A function. But it'd be useful to get a general feel from the group you have in terms of what your biggest challenges have been.
I guess for many of you, it'd be a mixture of all those things to some extent. But if there's anything obvious that is the sort of primary one, then yeah, do click on that box.
Mental health, yeah, I'm not entirely surprised by that, Greg, actually, in terms of, I think it has been a big issue with the toll of the last 2 years. Is a big one, yeah. And again, maintaining engagement in that remote setting where people have gone off and done their own thing, working in isolation possibly, and then trying to bring them back into the workplace. Absolutely. So if we move on to the last one, so again, that was sort of looking back, but then sort of same question looking forward. What do you think what's going to be your biggest challenge going forward over the next during 2022? Again, obviously some of these are going to sort of overlap with what we looked at before, but again, so it goes managing return to the office, hybrid working practicalities, both kind of split of home working versus office working. Again, just general handling ER issues, mental health again going forward, staff engagement, or again some other reason. What do you think? What's on your agenda for the year ahead, and what do you think you're going to be tackling?
Well, someone put in the Q&A for the last question was dealing with heavy workloads, and certainly it's something that we've seen from many employers over the last 2 years. Is many businesses, certainly in our region, have had a huge amount of work on during the pandemic. Not everyone, of course, but many have, and that pressure that puts on people who have sat at home day in day out has been quite challenging, and that of course then will link to the mental health and disability issues as well. Yeah, quite an even split, isn't it, Will?
Yeah. Again, I don't think there's anything particularly unexpected there. Again, there's all sorts of issues for everyone, aren't there? It's just a good chunk of it's going to be that whole new world thing, isn't it? In terms of coming back to work, the home working, office working balance, those sorts of handling all of those sorts of issues. Yeah, again, getting staff back engaged and back with the ethos of the business and all those sorts of things going forward. Yeah, absolutely. That's really interesting.
Part of the rationale, just to explain, was that we're looking forward as well in terms of next seminars. So we did want to ask those questions just to get a sense for what we might choose as topics for our next seminars going through into the spring and summer of this year, which may or may not be in person, who knows, but we shall see. So thank you for your input on that. I was just going to pick up on a couple of questions. I think we've probably got 2 minutes that have been raised in the Q&A. So a question about vaccinations. I'm sure Many of you businesses are struggling maybe with the approach to take with unvaccinated. There's lots in the press about it. Question was the unvaccinated case due to the nature of the work stroke job? So would the same apply to less customer facing industry? Well, the unvaccinated case was definitely, the nature of her role was absolutely pivotal. She was a care home worker, and it was at a time when the vaccine had just been rolled out, but care homes needed to take a robust approach in relation to their approach to staff vaccines. And of course, the vaccine law in relation to care home has moved forward since that case. Whether or not you are going to be able to take a blanket approach that all your staff must be vaccinated will depend entirely on your business, and it would depend on the size and nature of the work you do, how many staff you have. But the general consensus is that it's fairly risky to take a everyone must be vaccinated approach. You must think about people's disabilities and other protected characteristics. But what we're seeing, you've seen in the press, I'm sure, in the last few weeks, is measures being taken by some employers to almost incentivize people to get vaccinated, or to for example, the sick pay point is that if people are unvaccinated and are off sick, then with COVID, then they'll only get statutory sick pay. They won't get the company sick pay. That we've seen amongst a number of employers, and that's been in the press as well. So I think we're going to start seeing more cases come through. Bear in mind that all the cases that we picked out on COVID were only tribunal level cases, haven't been appealed. We've seen nothing from the Employment Appeal Tribunal, nothing from the Court of Appeal yet. But that will happen, and we'll see more first instance tribunal cases on vaccinations as well. So keep an eye out for those, and we'll do our blogs and updates as they come through. I think what we'll do, we'll draw it to an end there. We're just over the hour. There's a couple of other questions which we will respond to in our communications after the webinar. Can I thank you all for attending? There's been a huge response and attendance rate on today's webinar, so thank you for that. On behalf of Will, I and the rest of the team, we look forward to working with you over the coming months, and we will see you when we see you. And on behalf of us all, can I wish you a good day, and thank you for joining.